an email that I sent from asking for comments from well, any number of people, but this is the one that I got back most recently. Let me just walk through this very, very quickly. So on I guess it was New Year's Eve, I sent an email to the PIO at the Indiana State Police requesting some information about Holeman's interview. I wanted to find out, just about that interview. I called McCleland's office on New Year's Eve just to question him about initially about what was going on with the Mitch Westerman case being dismissed. And then I reached out to Holeman directly via LinkedIn, because why not try there? Haven't heard back. And that's when I sent this kind of rambling, honestly, email to the PIO. And then I was lucky enough to get sort of a quick dialogue going with the Office of the Inspector General of Indiana, who happens to oversee the Indiana State Police. And I just figured, why not copy them on this, because it's probably going to become part of some sort of, FOIA information. But essentially, I got just highlighted this quickly. I had put together some concerns about the first week Mr. Allen was in custody, and the issue of transport from Carroll County Jail to White County Jail, the issue of having retained private counsel yet not being provided or not being brought to the safekeeping hearing, and then basically being renditioned to the Department of Corrections, where he was then subsequently put in solitary confinement, which obviously is torture under the Eighth Amendment when it's done to the degree that it was done to Mr. Allen. Also, Geneva Conventions, just throwing that out there. But so anyway, this morning I got, I had laid out in this email, and I copied everybody, including Nick McCleland, because I hadn't heard back from the phone call I had left him. Just that, you can kind of see here, just laying out that what I just said, that he had counsel, that potentially this could be something, not being able to be present at a consequential hearing on his safekeeping, and having the right to be there to either accept or reject this, that could in fact be not interpreted as, but in fact is a structural error that would, under federal criminal rule procedure and also Indiana procedural due process procedure, would be grounds for an immediate reversal of the guilty verdict, which would be devastating, but also potentially in furtherance of actual justice in this case. Anyway, I laid that all out there. And I just, prefacing all that gobbledygook I just said in the last 5 minutes, basically the takeaway is, you can see here, there's a newly appointed superintendent of the ISP, Anthony Scott. I haven't looked into him yet, but the one thing that I wanted to make sure that I at least reiterated with the Inspector General's office, and again, I know that there's, the court system, there's the judiciary, of Indiana, which doesn't fall under the auspices of oversight of the IG, but it seems kind of like an all hands on deck type situation in this particular case, because it's such a train wreck. When you see here Mr. Cook responding to the questions about the potential for structural error, just that, quote, he writes here, highlighted, the questions you pose most certainly are subjects that will be reviewed on appeal if properly raised. I mean, here's hoping, right? Because I think that the ability to file the motion to correct error really should be something that the trial court can't or shouldn't ignore at this stage. I think that would be really egregious. I mean, there's been a lot of egregious things in this case, but I would just encourage everybody to reach out to literally everyone in Indiana